My dear friends, today's subject is custom as a source of law. My name is K. Umesh Rao. In this class, we are discussing custom as a source of law, reasons for treating custom as a source of law, essentials of a valid custom, kinds of custom, usage, and difference between custom and usage. Now, custom as a source of law. Custom is an important source of law. You know, other two sources of law are legislation and precedent. Customs means those rules of human action established by usage and it is legally binding by its followers. Custom, it is a primitive source of law. It is the oldest source of law. Custom comes first. Legislation, precedents are the latest development in the administration of justice. Custom and law. What is the relationship between custom and the law? The relationship between the law and the custom is coexistence. Now, what is custom? Customs means uniformity of habits or conduct of people under like circumstances. People use and practice these habits from time to time. Because of the frequent use and multiplication of the use of this act becomes custom. Custom are those rules of human action established by usage and regarded as legally binding by those people whom rules are applicable. Custom, it is a manner of acting regularly observed in a community. For example, wearing a black clothes at funerals. It is a custom, but it is not a law. So it is a rule existed from time immemorial and it is the force of the law in a particular locality. Reason for treating custom as a source of law. What is the binding force of custom? Why custom is given the force of law? Custom is the embodiment of those principles which have commended themselves to the national conscience as principles of truth, justice, and public policy. Customs means people of the nation accepted it. Custom deserved to be called as a law. Custom started from the natural principle of justice and public utility. Custom is to society what law is to the state. State has the power to make laws and enforce them. Law is the instrument of state, but society has no power to make laws. Custom is the instrument of the society. Custom is the public opinion of the society. Some customs accepted by courts of law. Custom should be accepted by the court of law as a guide. Salmon said, custom is to society what law is to state. Custom is observed by large number of persons in a society and in the course of the time, same comes to have the force of law. Custom is established one. Custom is widely accepted one by the society. Custom acquires stability and certainty as time proceeds. For example, Hindu marriage performed on basis of customs. Here comes Kanyadan, Mangal Sutra Dharana, Saptapadi. These are all the customs. But as in the Hindu Marriage Act 1955 recognizes all the elements in the Hindu marriage. So custom rests on the popular conviction that it is in the interest of the society. Customs provide material out of which law can be formed. Custom is related with the principles of religion. Why? In olden days, there was no law, no codes. There were kings and religious heads. People followed the principles, religious principles blindly. These religious principles converted into custom. So branch of the law did not start from legislation. In fact, branch of the law started from custom. The reason, what is the essentials of a valid custom? Customs must be reasonable. Custom should be reasonable and it should be useful to society and it should provide justice. It should be based on public policy. Essentials of a valid custom is that it should be reasonable. It must be useful and convenient to the society. Unreasonableness of customs means its enforcement results in greater harm to the society. If customs is not reasonable, they are definitely set aside by the courts. Another important essential of a valid custom is custom should be immemorial. In order to become a custom or valid custom, it must be proved to be immemorial. It must have been used so long that it is beyond the memory of man. Nobody should say that I have seen the beginning of this custom. In order to become custom, long usage of practice is essential. Custom should be useful to society and it should be based on the public policy. So valid custom must not be opposed to public policy or principles of morality. Customs must be conformity with the statute law. No custom can take away the force of the act of the parliament. Statutory law is supreme. As a state can abrogate a customs, but not vice versa. Custom is a source of law, but it is not a law. Customs must not conflict with the statute law. Custom should be, it must be consistent. It should not conflict with the statute of law. No customs can take away the force of the act of the parliament. A state can abrogate customs. Customs must have been observed as a right. Customs must have been followed openly and it does not require force. Customs must be followed by all the people of the society compulsorily. So custom, in order to become valid, its observance should be compulsory. An optional observation or optional observance of custom is ineffective. Court has to satisfy itself that custom is observed by all the concerned and not by anyone. General and universal. Customs must be general and universal. Custom is effectual only when it is universally accepted. Customs must be definite, it must be certain, and vague or indefinite on the ground is not acceptable. Custom should be continuous. Customs must have the continuity observed without any interruption from time immemorial. If custom has not been followed continuously or uninterruptedly for a long time, the presumption is that it never existed at all. So customs must be consistent with each other. It must not conflict with the other custom. If it is conflicting with the other custom, then it is not at all a custom. Custom must be continued and unaltered and uninterrupted. Kinds of customs. There are two types of customs: legal custom and conventional custom. What is legal custom? Legal custom has a binding force on the practice irrespective of their consent. This legal custom always speaks about the agreement between the parties. So legal customs must have existed for a long time and immemorial past. Legal custom is a source of law. Its legal authority is absolute. It acquires a force of law. See, legal custom, it is relating to the trade and practices of trade. There are two kinds of legal custom. One legal custom, local custom, and another general custom. Local customs means it prevails in some defined locality only. General custom means it prevails throughout the country and it constitutes one of the source of the law of the country. Another is conventional custom. What is conventional custom? Conventional custom is called usage. It has a binding force on the parties only when it is not expressly excluded by the terms of agreement of the parties. Conventional custom need not be of immemorial past or antiquities. It may be a recent one also. Conventional custom is not a source of law directly. After long usage, it is converted into custom. It is not a source of law directly. Its authority is conditional on its acceptance, on its incorporation in agreements entered by the parties. Statutes developed from the legal customs are conventional custom, law of merchants. So, conventional custom is one which authority is conditional on its acceptance and its incorporation in the agreement between the parties to be bound by it. It is established practice which is legally binding because it has been incorporated in the contract between the parties. When two parties enter into contract, they do not put down conditions in black and white. There are certain implied terms which can be omitted also. But contract become complete only when we take into consideration the implied terms. So certain conditions must be satisfied before a court is entitled to incorporate the usages into contract. So usage must be so well established. Now, elements of custom. Valid custom has a force of the law. It is a source of law. Custom to society, what law is to state. Customs not restricted to limited period, it extends to long period. Custom touches all the branches of the human law like marriage, adoption, business, ceremony. Customs may be local or spread over to the entire country. Thank you.